Hi guys, this is your feedback session for International Contract Drafting course. We'll be covering contract enforcement in the UK along with another class on contracts and advertising in the US. So this is just to make up for the previous feedback session that you missed when I was taking over from Parlevi. What was the exercise which was initially given to you, and then we'll move on to the feedback. So if you remember, this contract enforcement in the UK exercise was basically about Fred Hawkins, an American designer in India, and he got a gig on Upwork regarding this UK-based company known as Spencer Books. It was a children's book that he wanted to develop illustrations on, and it would basically be published on by Spencer and will be sold on Amazon. Of course, both the parties wanted to enter into a non-disclosure agreement. But before that, Fred had some questions regarding how contracts are supposed to be enforced in the UK. So he had certain questions. And in the next part, since he was satisfied with your answers, uh, he wanted to send you an NDA copy for your vetting, for you to vet, of course. And, we just asked you to draft certain clauses. So yeah, let's just have a look at a sample, right? So over here, so of course, the first question was how are these contracts enforced? So if you see that the person has written more about India's relationship with the UK and basically more about historical and political ties to India and the UK, especially the Commonwealth system. Uh, To be honest, I was expecting more about how contracts can be enforced in terms of the court structure as to, let's just say, if you want to file a civil suit, uh, how would you go about that? You could have given, an example of the county court or, different scenarios or illustrations as to how, let's just say, if a contract is to be enforced in the UK, what fundamental judicial forum that you would be going for, right? So simple in that regard. I think the next question regarding that was assuming one of the parties gets the judgment in the US, can the judgment be enforced in the UK? If yes, state how the judgment can be enforced. Again, a very much similar, question as to the previous one. Yeah, I think Oh, sorry. I think this is the first. This is between India and UK. Let me just get back to it. Uh, Sorry. So this one, in terms of English law, so this person has actually answered it over here. And is it any different from India? English law comprehends all that would be real property as immovable property. A lease person talks about land and everything. With regards to immovable property, I think this is more of a what you call an example. But, again, try and explain it in terms of enforcement, how civil courts function in both UK and India. Try and, stick to the fundamentals of Indian contract law and the UK contract law. So that's what we wanted. This is the first answer. Yeah, coming back to the second question that I just mentioned, that assuming one of the parties gets a judgment, can the judgment be enforced in the UK? So assuming one of the parties, yeah. So the contract can be enforced in the UK. Party should consider the following practical steps. Party should not fear choosing English law. There is no substantial change to the rules on applicable law. Again, what substantial change? Is it because of Brexit? Are you trying to mention Brexit? Try and mention that. The person mentioned that they should be aware of the risk. Parties concerned about info should consider arbitration, of course, and they should review dispute resolution processes. So I think that is fine. Third question of there is a breach of contract between Fred and Spencer Books. What time frame does the aggrieved party have to institute a suit? So again, a limitation act you had to mention and allows breach for contract and tort such as negligence. Such actions to be brought within a period of 6 years under a simple contract. Otherwise, unless stipulated, these time periods begin either on the date of which the breach occurred or the date of negligent act or omission occurred. I think this is absolutely fine. What is the ideal court for the aggrieved party to file the suit? The high court is the ideal court to refer. I think again it's just an aspect or half of an answer. Commercial court deals with such aspects. It involves contracts, insurance, reinsurance, and sale of commodities. Same goes for import, export, and transport of goods. It also handles, disputes arising out of arbitration proceedings, and it's the, subdivision of the Queen's Bench division of the High Court of Justice. So I think this is covered in the class. If you just have a look at the slide, even though extensions were not given, so it was up to you to, figure this out on your own research. But yeah, the commercial court should have been the better answer. If the dispute emanates from a commercial transaction, what is the ideal court to file the suit? I think, again, ideal court would be the Court of Appeal. Absolutely no. Court of Appeal is more of an high court, right? So your screen sharing is paused. Just hold on. I think I'm having a problem. Yeah. I hope you all can see my screen. If the dispute emanates from a commercial transaction, the ideal court to go to would be the right court of appeal. Again, a court of appeal is basically an high court, right? If anything wrong goes with your contract in India, you have to go to the civil court rather than going to the high court. So again, commercial court should be the correct answer. Again, guys, if my screen had, if there was a problem, if you were not able to see my screen, I'll just repeat. Try and mention English, the difference between English law and Indian law in terms of where or what would be the correct judicial forum on this in this first answer, right? Second, if you've got a judgment from the US, just mention exactly from the playbook exactly what was taught to you in the class. They should not fear choosing English law. They should be aware of the risk. Try and mention arbitration as a possible example and possible alternative, and review your dispute resolution processes. Limitation Act of 1980 in the third answer, and the period of limitation is 6 years. So try and mention that. Ideal code for aggrieved party to file the suit. High court is not the answer. Commercial court, which is a subdivision of the Queen's Bench. And again, commercial court is also an answer over here. Now, exercise 2 was drafting in India. I think this was a well-drafted agreement in this particular scenario. Try and always mention that how you're defining an agreement. Over here, this agreement, selling illustrations for children's book, hereafter known as agreement, is made on this day. So always put this in capital form, the first letter, and try and mention what is the receiving party and the giving party, disclosing party, sorry. So Spencer Book is the receiving party and Fred Hawkins will be the disclosing party, right? Whereas disclosing party is engaged in the business, again, the trying and mentioning the engagement of business and the nature of business of both the parties. They are interested in discussing a possible agreement. Slightly vague. What is this possible agreement? Over here, you have to mention the nature of this agreement or try and mention or just stick to the basics, try and mention the nature of the business of both the parties, right? So that would be it. When it comes to confidential information, again, confidential information should be in capital form. I think the rest of it, the person has. So if you mentioned inventions, ideas, research, format, media code, data programs, this is not really needed, right? This is no inventions are part of this. So yeah. Product plans, product service customers, yeah, not really. But yeah, that's all in all, it's okay. All in all, it's I think if you've taken it straight from the contract, try and avoid it. But let's just say computer models, program, research figures, statistical data. This is not really needed, and because it's fundamentally an NDA between an author and a publishing company, so you don't need all this stuff, right? I'll just highlight this in red. This is not needed. Non-disclosure and confidentiality. Again, receiving party shall not, without the prior written permission of the disclosing party, directly or indirectly disclose or possibly disclose any confidential information to any third party. This is fine. Reasonable steps necessary to protect the integrity of the confidential information. This is also fine. Receiving party shall promptly inform the disclosing party of any accidental disclosure. This is very important. What happens when, if you committed an accident of this sort and you don't know where to go, right? This is important. Receiving party shall use the confidential information only for the purpose which it was provided and shall not profit from it, right? This is also a very, very imperative element of such an agreement. Yeah. So the receiving party shall strictly adhere to the provision mentioned above, except information has to be the information is already in public domain. So you have to mention what is the confidential information and what is not in confidential information. Differentiate between the two, and this is a good example. Clause 2.1 and clause 2.2. Right? Non-compete, no competing businesses. It's a logical part of the NDA. Same goes for non-solicitation. Remedies, governing law. Don't write remedies. Better to write governing law. Over here, try and mention exactly where you will have it. This person has kept it as Wales, so that's fine. Yeah, and this is it when it comes to contract enforcement in UK. Now we will move on to contracts and advertising in US. Right, so we were discussing laughing stock. I'm not sharing the exercise because it's fairly recent. So laughing stock was an advertising company which was looking to advertise their comedy content in the coast of the US. They were looking for advertising agencies. They found Madcap, which was interested in doing so. But before that, they wanted to understand how, certain aspects like UCC and advertising laws in the US work. So yeah, first question, I think this is absolutely fine. Explain the UCC. It's a comprehensive set of laws governing all commercial transactions, and uniformity of law is an important aspect of that. And it covers sales, leases, negotiable instruments, bank deposits, funds transfer, letters of credit, etc. Right? So again, sticking to the playbook, this is absolutely fine. Difference between India and US contract laws. This is straight away taken from the slides or the chapter. Guys, try and do some extra research. That's really appreciated. But yeah, if you've done that, we would really appreciate better from you. I think we're very, 4-5 months into the course. So yeah. How does advertising law work? Is it any different to that of India? So yeah, FTC, you have to mention the FTC Act, Dodd-Frank Wall Street Reform and Consumer Protection Act. Each state regulates its own advertising and has its own regulations. So try and mention that too. And also the same goes for counties, as had been mentioned in the class. FTC also regulates how one can collect data on children, and also has certain protections which it provides all the general public from social media influencers. So that's an important element. Now, I think this person hasn't mentioned, the difference between India and the US. India does not have an absolute regulatory commission or any regulatory act like the US does in the form of FTC. But India does have the Advertising Standards Council of India, and the council ensures the representation things made with the advertisement are true and honest. They should not be offensive to any group of people, and they should they should maintain the standard of public decency. Any sort of vulgar material that you may see online that can be removed on your television screen or your even newspapers, right? So that's not a part of that. Self-regulation is adopted, but yeah, in certain cases where certain laws come into the picture and they create some sort of friction between advertisements, that's where the problem arises. And you can always mention the legislation like the Indian Penal Code, Indecent Representation of Women, uh, Prohibition Act, Cigarettes and Tobacco Products Act of 2003, and also the recent guidelines on digital advertising. You know, so if you haven't mentioned that, try and consider mentioning that. And advertising agreement. Yeah, advertising. Yeah. So I think it's a very well drafted agreement. That's what I've seen. They mentioned the address, and the same goes for Madcap. So we have to be wary about that. And yeah, the definitions that you're given in the sample agreement, try and stick to those. Do not, you know, stray away from those. Always try and mention these smaller aspects like these clause numbers and sub clauses. You also see that you guys do not make such mistakes. Again, we are so far into the code that we do not expect you to do so. This person hasn't made that. Provision for information, what would be the provisions for what sort of services will this advertising agency be providing? So that's important. Obligations of the advertiser, SEO, text ads, image ads, all these are important aspects for any sort of advertising agency, social media advertising, and viral advertising, video advertising. Yeah, mention all of these. These has to pay the advertiser $100,000 per month. Uh, that's too much. I think since it's an Indian company, it has to be little low. So yeah, otherwise it's fine. Management of advertising budget. Uh, this is also manner of payment you have to mention during the course of advertising agreement, and in addition to those fees outlined in clause 4, the company undertakes to pay the advertiser to be used to meet the direct costs of advertising campaign. That has to be mentioned. Uh, Termination, what would happen in terms of termination, or on the event of termination, you have to return the budget, right? Duration, 60 days. I think that's absolutely fine. Everything like something like that. If you want to renew it, you can also mention that. Warranties and indemnities. Again, this person has stuck to the fundamentals, and that's completely fine. Same goes for confidentiality. No confidential information has to be disclosed. Same goes for the advertiser and basically the advertiser rather than the company, because all the information that the advertiser receives is from the company, whatever interest that they receive or whatever product that they wish to launch, uh, regardless of how innovative or how new it is, that has to rest with the company. So that's very important, imperative. Same goes for variation. Any sort of alterations have to be made in writing and signed by both the parties. And yeah, I think these are all very much, expected governing law and notices. So yeah, I think fairly simple. If you stuck to the playbook, that's absolutely fine. And yeah, that's it. If you do have any issues with regards to the feedback, or if you have any further questions, please let us know at support@lawsico, or you can also email me on my email ID. And yeah, I look forward to meeting you guys again in the next class. Thank you so much.